In 1988, after 28 years of service with the Ontario Provincial Police, Constable Gordon Domm retired. In May of 1989, he formed the Guelph-based Citizens Coalition favoring more effective criminal sentences. In the Ontario election of 1990, Ontario's Liberal Premier, David Peterson, lost his seat to New Democratic Party candidate Marion Boyd. An English major with a history of union activism, Boyd was also a noted radical feminist, one of a group of noted militant feminists in London, Ontario. Boyd was also a former executive director of the London Battered Women's Advocacy Clinic and had served 2 terms as president of the London Status of Women Action Group. In mid-June of 1991, 14-year-old Leslie Mahaffey went missing. On June 29, 1991, her disconnected remains were found encased in cement in Lake Gibson in St. Catharines, Ontario. On April 16, 1992, 15-year-old Kristen French was abducted. Her body was found on April 30, 1992. On November 2, 1992, now Minister responsible for women's issues, Marion Boyd announced in the Ontario Legislature that, quote, November is Wife Assault Prevention Month in Ontario, unquote. She asserted that, quote, assaulted women live in a state of siege. Like prisoners of war, women do what they must to survive, things that may not make sense to those of us who stand on the other side of the barbed wire fence, unquote. 3 months later, on February 3, 1993, Marion Boyd was appointed Attorney General, Ontario's first female Attorney General, and also its first non-lawyer. On February 17, 1993, Paul Bernardo of St. Catharines, Ontario, was charged with the rapes of numerous women that had occurred between 1987 and 1990. On February 22nd, the Toronto Star ran a story in which Karla Homolka, Bernardo's wife, was alleged also to be one of Bernardo's victims. It stated that Bernardo was expected to be charged in the slayings of Mahaffey and French. It reported that Homolka and her lawyer had been discussing with the Attorney General's ministry whether or not she could help in the probes of the homicides of Mahaffey and French. On February 23rd, Attorney General Marion Boyd announced that Paul Bernardo would be charged with the French and Mahaffey slayings in a few days. It was reported that Homolka was trying to reach an agreement with officials at the Attorney General's ministry, quote, giving her some form of immunity for her testimony in the 2 slayings, unquote. On February 24th, Attorney General Marion Boyd was roundly criticized by the Criminal Lawyers Association for saying Bernardo would be charged. Perhaps realizing she had said too much, Boyd flip-flopped, saying she did not know when or if Bernardo would be charged with the slayings of French and Mahaffey. On February 26th, Boyd turned on the media. In a media release, she announced that she was concerned, quote, about the nature and extent of the media coverage, unquote, and that she had asked officials to investigate whether, quote, any action should be taken, unquote. No specific media reports were mentioned, but clearly, something had been published that Boyd did not want the public to read. On May 18, 1993, Karla Homolka was charged with manslaughter in the deaths of French and Mahaffey. Bernardo was charged that day with first-degree murder in those slayings. On June 28, 1993, the Crown brought a motion seeking a publication ban, allegedly so that Bernardo would get a fair trial, although Bernardo opposed the ban. Bernardo's lawyers argued that, quote, the suggestion has been made in the media that she, Homolka, is a victim of my client, unquote, and that if a publication ban were imposed, quote, that would only foster the impression, unquote, that Homolka was a victim of Bernardo. Bernardo's lawyers argued that, quote, given the possibility that there is a negotiated settlement in Homolka's case, a ban would lead to a misleading impression of the case. The impression is that following his arrest, he, Bernardo, is depicted as the principal, and his wife is seen as assisting the Crown. If there is a ban, what you will continue to have is the same perception in the newspapers, that he is the principal, unquote. On July 5, 1993, Judge Kovacs imposed the publication ban. The next day, in a one-day hearing, Karla Homolka was convicted of 2 counts of manslaughter and sentenced to 12 years in prison. The public was not told whether she had pleaded guilty or innocent, and none of the facts presented at the trial were allowed to be published. In a profile of Marion Boyd, published in the Toronto Star just weeks after Homolka's conviction, Boyd spoke of Homolka's case as follows, quote, for those of us who've worked in the battered women's movement, who know about violence against women, these are horrific confirmations of the kind of target that women are for violence, unquote. It was an odd comment to make in the context of a case in which a woman was convicted of manslaughter of 2 girls. It was a comment that implied that Homolka herself was a victim and a pawn in the slayings of Mahaffey and French. It was a prejudicial comment, given that Bernardo's trial would be almost 2 years away. Over the following months, American and British media issued reports about the slayings of French and Mahaffey. The reports were said to be drawn from statements made by those who were present at the Homolka trial. The reports did not portray Homolka as a helpless victim of battered wife syndrome, but as a willing and eager participant in the sexual torture and death of French and Mahaffey. The reports disclosed that at her trial, Homolka gave evidence that she had drugged her sister so that she and Bernardo could have sex with her sister's unconscious body. The evidence explained that her sister died that night as a result. Homolka was not charged for the offenses against her sister. Outraged that Homolka would serve only 12 years for her participation in what was arguably the most evil and twisted slaying in Canadian history, in late November 1993, retired OPP officer Gordon Domm mailed out to Canadians some news reports he had obtained from U.S. and British news media. He was charged with contempt of court. On May 20th, 1994, Gordon Domm was convicted. He announced that he would appeal the decision. On November 24th, 1994, the Toronto Star reported that items had been missed by police during their 1993 search of the Bernardo Homolka home, and that just days after the police search warrant terminated, the evidence was discovered in the house by movers working for the Bernardo defense team. The report said that the evidence was turned over to the Crown in August of 1994, more than a year after Karla Homolka's conviction. 9 days later, on December 3, 1994, Freedom Party of Ontario hosted a dinner featuring 3 speakers on the subject of censorship, publication bans, media access to government information, and justice. Gordon Domm was the key speaker.
I'd like to introduce our first speaker. This is a man who needs very little introduction to most of you here today, and he's the only member of Freedom Party that will be sitting on the panel today. I think that's important. We do have input from people that are not necessarily associated with the party, and it's a good thing to hear from other people and not necessarily, shall we say, in the party type of people. Robert Metz is Freedom Party president. He has been founding member. He's been the party president for 10 years. He was the party leader for a number of those years. But tonight he's here in a different role. In the last couple of years, he's represented the London landlord, Elijah Elliott, in a human rights complaint. And it's as a basis of that representation that he's here tonight. He published some information and has run into some problems with the Human Rights Commission. He's here to talk to us about that. He's been an advocate of freedom of speech for well over the 10 years that he's been with Freedom Party. He's addressed many government commissions, many public audiences, and has debated a lot of people that have promoted censorship as an answer to anything. So with that said, I'd like to introduce Freedom Party President Robert Metz.
Thank you, Lloyd. I have 10 minutes to basically make the fundamental point that I want to make this evening that we can carry on the discussion with later on. So let me get right to it. I hold in my hand a copy of Freedom Flyer, our party newsletter. This happens to be the June 1993 issue, in which I quite surprisingly found that during the course of my acting as a defense advocate for a London landlord for a Human Rights Commission, that part of what I had already printed here and already distributed became subject to a publication ban. Now, what I found was very interesting about the ban was it was very clear to the judge who banned it that this information had already gone out, that it had already been mailed to most of our membership, but that didn't seem to bother him. At the time of the hearings, this was brought to his attention by the Commission Counsel for the Human Rights Commission. And I'll be quite blunt, I'll get right to the offending paragraph right away, and I'll read it to you. This is the paragraph that we were requested not to make public, and I quote it verbatim. According to Elia, quote, during their initial investigation of the complaint, 2 representatives of the Human Rights Commission offered to drop the matter against him if he would give the complainant 1 month's free rent and make a public apology to his aging tenants. Mr. Elia says he refused their offer, sticking by his claim that he had never made any racist comments whatsoever and would therefore never agree to such a compromise. Unfortunately, Metz was unable to verify the Commission's offer at the Board of Inquiry when he was informed that it was not legally permissible to discuss any deal the Commission might have made at a Board of Inquiry hearing. So this is where I first found out that I wasn't permitted to talk about something like this. I wasn't permitted to bring up an issue such as a deal that the government is trying to make with the respondent. Now, I think when you see the difference between what the deal was and what the Commission asked for afterwards, you'll understand why they don't really want to make it public, what I just read. Because, I mean, after all, if they're willing to settle for an apology and 1 month's free rent, then how do they explain afterwards for asking for things like this once they're before a Board of Inquiry hearing? The Commission asked that Mr. Elia pay the complainant $10,000 for compensation to her dignity, $10,000 for creating a, quote, poisoned environment, $10,000 for reprisal. They requested that he provide translation services in the first language of his tenants, which happened to be Cambodian and Vietnamese in his situation. That he should also advise them of their rights and obligations in their first language, that he should give his employees the right to sign his checks, that he should pay $409,900 into a trust fund for the tenants, that he should spend $70,000 to reglaze the windows on his apartment building, that he should be forced to pay $6,000 to place a full-page ad in the London Free Press that would be written by the Tenants Board. And, I mean, this is just a number of the 18 things that they were going after Mr. Elia for, simply for saying that some of his tenants who make a mess in his apartments happen to live like little pigs. This trial lasted for about 3 weeks. We have over 3,000 pages of transcripts entering evidence on an issue like this. And then we wonder why, in a society such as ours, there doesn't seem to be enough money left over to fully fund adequate law enforcement, adequate protection of our rights. And fundamentally, that is what is at stake today. Why do we have press bans at all and media bans when it comes to the workings of our courtroom and our adjudicators? And I think it boils down to the fundamental thing of respect for the law. It's very important that we as citizens respect the law, and our lawmakers know that. And if we, for any reason, bring the integrity of due process into play, then people won't respect the law anymore. But unfortunately, you know, the one thing that's being ignored all the time is that respect is a two-way street. We respect the law only insofar as we understand that the law respects us and our rights. And the minute enough people in a society perceive a difference, you're going to have a greater degree of civil disobedience. Which brings us to the subject of our key guest, who will be introduced later on this evening. But what seems to have been forgotten in the whole process, you know, when I presented with Mr. Elia before the Human Rights Commission, the one thing I realized after reading the law is that as a respondent under the human rights legislation, he has no rights. His rights are very limited. All the rights go to the complainant. I even brought this up in the hearing, and the judge acknowledged it and said, well, if you want to give the respondent any rights, he can just launch his own complaint. So in other words, in order to defend himself, they weren't even giving him a process to defend himself. They wanted him to launch a complaint against who? I don't know who they wanted to complain against. But that was the only way that you can get rights under the human rights legislation, is by launching a complaint. Then you get a whole sheet of rights. In fact, it got so ridiculous with Mr. Elia that even the municipalities passed a special law strictly for him. They passed a law whereby if utility payments fall behind on the part of a landlord, the city will pay that utility payment and then add the cost of that to the landlord's tax bill and recoup it that way. Now, of course, as those of you who know and who have read our publications, the whole history of this case is published in our newsletters, the Freedom Flyer, which are out there on the table, and certainly avail yourselves of them, because I don't intend to go into all the details of that case. However, there's, the one thing I discovered that we're really missing here in the due process of law and equality under the law is what is known in, I guess, legal principles as a principle of isonomia. Basically, that the law shall bear equally upon all. It's a very important issue because, after all, let's face it, the provision of justice is the primary legitimate function of government. I mean, if we didn't have to have a government for any other reason, this is it. To arbitrate disputes between people who have differences between them. To settle violations of rights in favor of the person whose right was violated. And the way it is today, people are absolutely screaming for justice. And they don't see it. I think when I talk to most people, I think they basically understand that justice means punishing the guilty by restricting their freedom through fines and jail sentences and somehow aiding the person who's the victim. So what do we get from our lawmakers? Well, they blame society for all the crimes. They pass more laws restricting the freedoms of law-abiding citizens and give us leniency on the people who are actually breaking the law. So instead of effective sentencing, we get gun control. And every innocent person in the country who owns a weapon now or a gun of any sort has to go and register it as if though this is going to do something for the crime rate. Because we have Young Offenders Acts and we have some problems in the school system, well, of course, we can blame the problems of children on media control and problems with what they see on TV, as we just saw recently with the attempted banning of something like the Power Rangers. Just saw an incident here in London just a few weeks ago. Just down a few blocks down the street here on King Street, down at the other end, a woman was killed a block and a half away from an after-hours club called the Ramp, I think is the name of it. And as our adjudicators are thinking today, here they are, a block and a half away from the place. Someone kills someone. It is discovered that they were on their way to this particular bar. So what do? The Liquor License Control Board lists the license of this bar for 2 weeks, and now they have to search everyone that goes into the building with metal detectors. Now, the owner of that bar couldn't, in any possible rational way, have been held responsible for something that two people did a block and a half away, who just happened to be going to visit his bar, hadn't even arrived yet. So those are the kind of laws and the kind of ways that people are seeing things happen. And of course, to pay for it all, they give us more taxes, which I think lends truth to the old statement that a fine is a tax for doing bad and a tax is a fine for doing good. I think there's more truth to that than we can suggest. In any case, I would conclude simply by saying that the justice system has become completely politicized and that the solution is a political solution, but it has to come from a principled base, from a base that understands that individuals have rights and that individuals with those rights have responsibilities. And that's part of the social contract. When we violate the rights of others, part of that contract says we give up our freedom, that there are consequences to specific actions. And I think that is the proper function of the government, to enforce those rights and obligations. And when that happens, we will live in a truly free society. And we can certainly carry this conversation on to whichever direction you want when the question period starts. So I'm through for this section. Thank you very much.
Thanks very much, Bob. Our next speaker is a member of the media. He's worked in radio and is a freelance journalist for the Globe and Mail and other publications. He's presently the publisher and the founding editor of the Business Times, which there are copies of out in the other room if you want to pick one up. He's been recognized over the years with awards from the Canadian Association of Journalists, the Canadian Association of Broadcasters, Radio Television News Directors Association of Canada, and the International Radio Festival of New York. In 1991, he was named by the U.S. Free Press Association as one of the top 5 defenders of the U.S. Bill of Rights First Amendment. That amendment guarantees the fundamental freedom of religion, speech, and the press. Here in Canada, his work was recognized by then Governor General Ray Nititian with a citation for meritorious public service in journalism. David Helwig has been involved in the media for quite some time. He has some interesting insights, and I'd like you to welcome him to the podium now. David?
publication ban than I'll be able to tell you. But if there's one good thing that has arisen from that particular ban, it's that it's drawn unprecedented attention to a problem that many of us in the news gathering business are dealing with on a regular basis. The problem is access. Trying to gain access, in our case for our reporters and the public for that matter, to government meetings, to court hearings, and public documents. Let me tell you, it is not easy. I run a small business publication with an even smaller staff. We run into access difficulties at least once a week, sometimes on a daily basis. And we're talking about things, for example, in which we have to use the provincial or municipal Freedom of Information Acts or threats of court action in some cases. Our reporters are forced to leave discussions of important public business, often unjustly, sometimes illegally. Bureaucrats improperly deny access to government documents. In one case, I had to write letters threatening our court system with legal action just to get it to comply with its own law on access to court records. And this was nothing sophisticated, by the way. It was simple housekeeping records that there is case law going all the way up to the Supreme Court of Canada level, documenting that the public has a right of access to these documents over the counter, and we literally had to threaten them with legal action in order to get anything done, and at a very high bureaucratic level. There was a time, of course, when all of this was quite acceptable. Just under 400 years ago, James I of England very haughtily told his House of Commons that none shall presume to meddle with anything concerning our government or deep matters of state. In other words, he was in charge, he alone. He ruled by something called divine right of kings. Advice was neither sought nor welcome. There was absolutely no need for the public to have any idea what their government was up to. And of course, those days of absolutist monarchies have long since been dethroned by a system called democracy. Positions of authority are supposedly no longer owned by the office holder. They're the property of the people. The people, in turn, under a democracy, are expected to continuously monitor and evaluate the performance of government institutions and elected representatives. At least that's the way it should be. Now, over a 24-month period in 1991 and 1992, the awards that were mentioned relate to this, I conducted what is believed to be the most rigorous and intense investigation ever conducted into secrecy at the municipal government level. I did it in the city of St. Thomas, just south of here, and using the newly passed Municipal Freedom of Information Act in conjunction with some little-known sections of the Municipal Act, we found a way of getting into minutes of secret municipal meetings and getting them very, very quickly, as in the next day. We found, as a result of this 24-month investigation, that politicians, not only there but in many other communities, routinely dealt with contentious issues in secret meetings. It was the preferred way of operating. For example, I'll give you one example. The Police Services Board there, we found them secretly bullying a local author. He'd been commissioned to write a history of St. Thomas Police, and he was a retired dentist. And the board thought they'd get this nice, tame little history that they could distribute to school children. And what they got was a rollicking account. He got into the personnel records, and he got a rollicking account of cops indulging in booze, bribes, and brothels. And you need to know he left out the really juicy stuff. There was something in the personnel records about the police chief seen rolling out of a house of ill repute with his trousers around his ankles. That didn't even make the book. He was trying to show some discretion here. The Police Services Board, at the time that we caught up with the story through their secret minutes, were trying to confiscate all copies of the author's manuscript to stop him from publishing, trying to claim all photographs. And it all backfired, of course. When we came out with this, the story went clear across the country on the wire services, and one local newspaper actually published the entire manuscript in serial form. But if this investigation that we did proved anything, it's that governments cannot be expected to voluntarily give up habits of secrecy. They know too well that political advantage is easily gained by keeping the public ignorant of public business. People just do not complain about what they don't know about. Ignorance is bliss, and politicians learned that a long time ago. We need strong legislation, and we need comprehensive legislation that covers everything in the revised statutes of Ontario. Legislation with penalties to make sure that closed meetings and closed hearings are used only for legitimate purposes. Now, I am, as has been mentioned, I'm not here as a member of the Freedom Party. I belong to no political parties. But I am here, and I've done similar presentations about 30 times in recent months. I'm here to make people understand that when government uses needless secrecy, it thwarts democracy. How can you vote intelligently if you can never learn the positions advocated by your elected representatives? How can you vote knowledgeably if they make all their arguments in closed sessions? How can citizens respond appropriately to government actions if they can't find out what the actions are? How can we be assured that our courts are functioning properly, that the pressing problems of crime and violence that our society is trying to deal with, how can we assure that that's all being dealt with, that judges can impose bans on publication at a whim? I think the real problem here is that we don't really trust the jury system. We don't really believe that people possess enough common sense to be able to deal with the information that's presented in a trial. We want trials to be heard by juries of informational virgins. We're afraid that should these 12 people come into contact with something so dangerous as a fact that they will be automatically corrupted and defiled by it. Judges, in the course of a trial, routinely on a daily basis can take information and say, this is admissible, this is not admissible, and they shunt it aside. They do not supposedly take it into account. If judges can do that, why can't citizens? I think we have a jury system, and it's all predicated on the fact that people are supposed to have common sense, but then we don't give them credit for it, and that's the problem here. And to create just a dozen of these informational virgins, these people that have not been contaminated with facts and information, what do? We just need a dozen of those people. We decide that we're going to take an entire nation and we're going to make them all informational virgins so that we can have these 12 people. It's completely unnecessary, it's undemocratic, and it's wrong. If the law allows Gordon Domm's conviction to be upheld on appeal, if that's the way our judges are going to behave, then very simply the law must be changed. How that will happen is Canadians will have to stand up themselves and with one voice will have to indicate that publication bans, at least the ones we've been talking about, are undemocratic, unjust, and contrary to the public interest. What I'm saying is you have to stop leaving these battles to us in the news media. This is perceived as a media issue, and as long as the politicians think that's what it is, we will make absolutely no impact. It will take the people of Ontario and the people of Canada to establish the political clout to really make a change here. So what is needed is a stand for freedom, a stand for freedom of information and freedom of expression. And it's the people of Ontario and the people of Canada that will do it, rather than simply us in the news media who've been flailing away at this issue for years. So we really do need your help and support on this. Thank you.
Well, as you mentioned in your presentation, you have some concerns about the final verdict on our next guest, and that's Gordon Domm. Most of you know him. Recent media attention makes him almost instantly recognizable. He's currently the only person, I believe, that's been charged with violating the ban on the Karla information. He was recently found guilty of 2 counts of contempt of court and fined $4,000. That was resulting from that violation of the ban. These convictions are currently under appeal, and as a result, I believe you've been advised to refrain from discussing the case itself during the case, so you will temper some of what you say. And if somebody asks a question and Gordon feels that it's inappropriate for him to answer, please just acknowledge the concerns that he has there. He's a retired OPP officer. He retired in 1988, and in 1989 founded a group called the Citizens Coalition for More Effective Criminal Sentencing, or Sentences. And he's been with that for 5 years as their coordinator and spokesman. And in that role, he's here tonight. Ladies and gentlemen, our guest speaker, Gordon Domm.
I might be downhill from you from now on tonight because you've got some excellent presentations here, and they sure hit the nail on the head. Thank you, Robert Metz, for including me in your guest list for speakers tonight. I can't express too strongly how I feel about a group like yourselves so dedicated to the democratic principles of justice and freedom to invite me, a lawbreaker himself. But on the positive side, I did serve 28 years on the Ontario Provincial Police as a police officer, and I was fortunate enough to escape any charges whatsoever against me under the criminal laws of the land. But I haven't been so lucky since my retirement. Well, you might say semi-retired, but I did go out on a full 30% pension, so I'm living basically on my pension income. I do have a lot of support from the public. I have over 1,000 people on my mailing list, and I've had 257 people donate already, sums from $2 upwards, for a total of $6,547.30. I'm very impressed with that, although it's only a small portion of what I'll need on the coastal appeal, but it's certainly a fine, fine down payment on what future expenses I may have. My appeal is presently in the written argument stages, but it will be held up temporarily due to a similar case out in Martinsville, Saskatchewan, which I'm sure you all may be familiar with, a sex-related series of charges laid against different people where there was a publication ban because several pleaded guilty but on separate indictments. And the main argument that is being used is a similar argument to the one that's being used by the media here in Ontario, that the judge doesn't have the authority to issue a publication ban to protect the rights of another accused on a separate indictment arising out of the same set of circumstances. In other words, in both of these two cases, the Malta-Bernardo case, where a publication ban was issued until the duration of another accused person, and the same in Martinsville. That is the argument that the appeal courts are using. It's such an honor to be in front of a group of people who feel strongly enough about freedom to either belong or support the Freedom Party. The name in itself is music to my ears. I didn't know there was such a party until Bob called me a few months ago to see if I'd be interested in speaking here. Well, certainly I would be. I'm sure he's aware that there may be some backlash from some of the protectors of the status quo for inviting me here. But he's willing to take that risk in the name of freedom and give me a chance to talk to you. And I know there are some media here tonight, and I hope that they will carry the message forward to their readers and subscribers, and if there are radio stations here that I'm not aware of, to their listeners. We all gathered here under the banner of the Freedom Party. It's sad to say, many of us will feel uneasy and unfree and unsafe to walk the streets surrounding this hotel when this meeting is over. What a sad state of affairs. Let's see now. Is there anyone here that would feel perfectly safe about walking within 5 blocks of here, a nice stroll at about 11 p.m. tonight? Is there anyone here who would feel safe? 1, 2, 3, 4, 5. 5. Is there anyone here who would feel a little unsafe? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Well, that's just a little unscientific poll, but I think the numbers would be pretty similar if you took it down the street at 10 o'clock in the morning. There might be a little fear about answering, I don't feel safe here at 11 o'clock at night, because you might get beat up for it. But you might not get it. You might get a better percentage for the 5 supporters of the 5 that think it's safe. But there's certainly, it's a sad situation. They're taking the guns away from the good people. Someday, if the good people need them to defend themselves, they won't have the protection. Sad situation. Because the criminals will still get guns, and some of the good people will still get the guns, but they'll be encouraged to get them illegally, because they're gradually taking away our rights to bear arms. And under certain conditions, if we don't bear arms, we're not going to be able to protect certain properties that we might have, or if the employees who are responsible to protect those properties, because the guns will be made available. See, I have here a flyer from the Freedom Party that impressed me very much. Of course, the bottom quote, Freedom Party believes that the purposes of government is to protect our freedom of choice, not to restrict it. But what's really happening today is governments are protecting the rights of vested interest groups who shout the loudest and have the most votes and the most support to offer the government power. And they're doing that at the expense of people like you and I as individuals. You see, I'm not defending Paul Bernard. I think he's involved for sure, but we have to prove that in court. Don't we? I thought that was what criminal law was all about. The whole justice system, of course, needs to be looked at with a fine-tooth comb. Parole. Parole should be abolished. Plea bargaining should be abolished. It brings discredit to the justice system. Now, to be able to cover up plea bargaining and publication bans is double jeopardy as far as I'm concerned. The Young Offenders Act obviously should be abolished. We've got to come up with bills that will treat everyone the same for a crime that they have committed. I am a little upset. I guess you've noticed that. But things have a way of working out for the best. And I do have a lot, and I'm very impressed, very overwhelmed support from the public on what I've done. The fight's not over yet. Thank you a million for having me over.
As we say, what we're going to do is work in a type of question and answer and discussion format. We certainly will take questions from the floor. There's no problem there. I guess maybe one thing, I'll try to kick it off, and I'm not sure whether you can really address this, and this is to Gordon. You've worked for so long with a group of people dedicated to more effective criminal sentences. How did you go from that to being what we see in the media, the notorious Gordon Domm, the breaker of the Karla Homolka ban and all of this? Was it your intention to set out and break the ban, or was this just something that you fell into?
The research I did led me to believe, beyond any doubt, the ban did not apply to me, because I was not a publisher or broadcaster. The definition of newspaper, which are clippings from the newspaper that I had distributed, didn't feel applied to me. And as to why I broke the ban, but I continued to lobby for stiffer standards. Well, initially it was issue. Too light a sentence for a double manslaughter conviction. Case of Karla Homolka now, I guess. And I felt that the sentence would have been higher had it not been publication banned. And they were hoping that without too much publicity, the public wouldn't be too outraged over that sentence. So it was a sentencing issue at the beginning, but it developed into a freedom issue when I realized that they were trying to encompass the general population in the court ordered ban. The way I read the criminal code, it didn't provide for that. So I went ahead, clipped articles in newspapers, and mailed them out to people who actually requested them.
I guess a question for David, and this relates to the media and bans. This is actually, I'm taking this from, it's a Maclean's article that's an excerpt of a book. The book is called How the Media Distort the News. So obviously I'm leading into something here. I guess one of the things was that the media, and I'm quoting here, proclaimed that this was a denial. This is the ban on the Karla Homolka information. It was not just a denial, not just of press freedom, but a fundamental of the justice system, namely that justice must be seen to be done. The author goes on to say it's debatable because nowhere is it written that the press have to be present for justice to be done. But do you see that the ban has really any relationship to the public's perception of justice?
I think so. If we're going to have a justice system that people have confidence in, it has to be a transparent one. And you see, any discussion on this seems to gravitate also to O.J. Simpson right now, because there's. I can't say that I'm altogether proud to see everything that's happening there, but it's to me there's something wonderful that happens when the public gets access to court proceedings. I just want to do a straw poll here. How many in this room have had formal training in law at either the secondary or post-secondary level? How many have taken a course in Canadian law? If you just raise your hand. It's a definite minority. And I believe that that is true of the population in general. And I believe that, frankly, the vast majority of us, most if not all of what we know about law, is derived from the mass media. It's a marvelous educational tool. And I'm not saying that there aren't abuses, but I think the abuses pale in comparison to the educational value of having an open and transparent justice system.
Well, I think he's pretty well clarified in my mind that there'd be less distortion if the facts, do you not believe that the facts were put out maybe on live TV, like they do in the States, that we'd have something to discredit the tabloids or the gossipers if they were putting out, or the internet networks, if they are, putting out false information. They wouldn't get away with it. That's all there is to it, because it would be documented for all to have seen on TV. They wouldn't dare. You don't agree with that?
I think, too, when we're talking about reading the facts in the paper, I think if there's one thing that a press ban will tell you, or a media ban, I mean, there's only one thing around to ban, and that is the truth. There is no other victim to a ban. And that is a telling thing, that our government, through its court system and through all its bureaucracies, is effectively telling us it's okay to spread gossip and rumors and lies and innuendo, but by gosh, if you tell the truth, we're coming right after you. And that's essentially the message we're getting. And, you know, to get back to the situation where I wasn't even sure when we printed in the Freedom Flyer whether or not the story relayed to me by Mr. Elias was in fact true or not. And I even hinted that there may be some doubt about this in the newsletter. But I'll tell you, the minute that they put a press ban on that paragraph, I knew it was true. There was no doubt in my mind. So I think to suggest that we can decide better, you know, either as jurors or anyone participating in the system, because we've been inundated with a whole bunch of irrelevant facts, lies, innuendos, rumors, then if we were faced with the truth, I just can't see how we lose by knowing the truth. I mean, that's what we're trying to determine in a court, and people who go into a courtroom certainly have to make that determination on their own. I've always said myself that I'd rather hear a lot of rumors, even if I can't get anything else, that if I was a juror, to go in and then suddenly hear the truth, I can start discounting what was phony from what was true, and you still go through the same process once the evidence is presented. So unless we're a bunch of automatons who can't think for ourselves, we're certainly not fit to be jurors, and we're not fit to vote, so the whole issue is moot. From my point of view, all information should be, legitimate information should be available to the public, especially what goes on in trial.
To take that a step further, and this is for you, Bob, do you think that the media can inform the public of the facts, and when I'm using the word facts, I'm using the truth. Can they inform the public of those facts in a clear and understandable manner when you get into emotional and contentious issues?
Well, they can, but they often fail at that task, and certainly in my own case, as a lot of you know, we saw the media as part of the problem. Having a free media, again, as I guess David Helwig hinted at, isn't going to guarantee you that you're going to get facts, but you're going to get bias. You're going to get a lot of bias in the media. And that's why I'm a big supporter of revealing your biases instead of always having to hide them. I'd rather know who is telling me something and what their bias is, and then I'm in a position to judge. But the less information I have, the less able I am to judge. So certainly when we look at the media depends on its reputation. And if a particular publication has a reputation for being accurate in the news, people accept it and respect it as such. If a particular publication is the National Enquirer, well, we all smile a little when we read about the two-headed Martian visiting the White House on the front cover, you know? I mean, I've seen stuff like that in those papers. So it comes down to an individual judgment situation. And it's always.
My name is Robert Bond, and what would happen to a publication such as Business Times, isn't it your publication? Or, for example, on the Free Press, or maybe a newspaper like Toronto Star? What would happen, and who would an action happen to if they actually did go ahead and define a ban?
It's not pretty obvious that almost every major newspaper across Canada has broken this ban. The ban was that there should be no publication of the details of the trial of anyone referred to, the deaths of anyone referred to in the trial. They were, of course, itemized in detail prior to the ban, but the ban ordered that there be no publication. Name me a newspaper you think hasn't broken it other than Business.
Yeah, we haven't. I can assure you of that.
I guess if I can jump in and then I'll go to you, Rick. Quick question then. Gordon, you're saying about so many people who violated this ban. What made you so special that you're the only one that's ever been charged?
They want a test case so they can broaden the authority of publication bans to include you, me, and everyone else, 26 million, 28 million people across this country. When a judge in one jurisdiction makes such an order. Two, I was the least likely to have the capital to appeal it.
It's just abhorrent that we can see reputable news organizations like the Washington Post and CNN and those things being censored in our country, and people being charged for possession and distribution of some of the best news products in the world. I really strongly object to the legal aspect. Do you know more about that?
Well, first of all, I don't believe that any of these media sources had an injunction through the courts issued against their distribution, but that the distributors here in Canada, voluntarily, under pressure from the Attorney General's Department, took them off the shelves. There was nothing in the court document specifically banning either of the newspapers that I had distributed. And I don't think there was anything that cohorted banning the TV channels in Canada, cable companies in particular, that required them to blanket that out. And there certainly wasn't any court order, I know for sure. against any media source or a specific broadcast. It's all pressure tactics.
To add to that, Gordon, I guess my question is, you're talking about the Attorney General's office, and you're saying about pressure.
Sure, there was pressure.
To my thinking, the only pressure they can say is, we're going to charge you. I mean, the Attorney General's office not liking you anymore, it just doesn't mean anything. Is that the only pressure that they can really bring to bear, is to say, we're going to make your life miserable through the courts?
Well, they warned me before they charged me in writing. But it didn't come from a court. It didn't come from a judge. I was warned by, allegedly, I think I'm going too far now. But,
We'll understand.
I can't control myself. I'm sorry. Hang me if you must.
Okay, the next person, I think Barry.
Well, I have a question for Gordon. Have to be rather delicate the way I place it.
Well, you're under no obligation. Maybe, yeah.
Well,
you might be years from now.
If I'm not delicate, I may not get an answer. First of all, I'd like to say that my wife sent me over to Buffalo to buy the Buffalo Evening News. And it was quite okay with Canada Customs to bring one copy back. 2 was a no-no. Did you learn anything other than was covered in that article that brought on your real sense of outrage as to the ban and the trial of Karla?
What I sent out was a copy of the Washington Post article and a copy of the London England Mirror article, cut out and photocopied on my photocopier to several hundred people who had requested it. Incidentally, I also sent out tapes of the current affair, 50 of them. But I never got even warned about that. I don't know why. I think there was something in those news stories that were true, or I couldn't have been charged for that.
That's right. Okay.
So they substantiate there's some truth in those news stories that I got charged with. I can't control myself. I know I'm not supposed to be saying this.
I'll jump back over to this side of the room. Okay.
Yeah, I would just like to tell Gordon how much I admire you, convicted criminal or not.
Thank you.
And I'd like to take this opportunity to thank you for spending your life putting the real criminals behind bars.
Yes, I have another question. And I understand, Mr. Domm, if you don't want to answer it because it's of a personal nature. I sat through a number of the hearings with Elijah Ilya, the Human Rights Commission affair, and I understand that there's more punishment that a person in your position would go through than is normally thought of, just with the expense of the court costs and with the embarrassment of being charged and with the time involved. There are other costs to this of a personal nature. I wonder if you wouldn't mind elaborating on perhaps some of those, if they didn't in fact you do have more of those costs.
No, I don't think so. I don't think so. I knew full well what the repercussions could be, but I don't feel that they're going to be carried into a field. I don't think they can substantiate the person being charged a non-existent crime.
So you feel confident then that this is just going to go where it's gone?
It's going to be tossed out in the field. Quite confident of that. I'm not supposed to say that, but the hell with it.
I have a point to raise about Mr. Domm's criticism of the plea bargaining. I wonder whether we don't have to draw a certain distinction here. I agree that plea bargaining is reprehensible, extremely reprehensible, if it leads to a reduced sentence for a dangerous, potentially dangerous criminal. But is there not a case for a plea bargain where you want to get a dangerous criminal behind bars and need the testimony of a relatively innocuous, perhaps an accomplice after the fact, and you need to get the cooperation of that accomplice by agreeing to a reduced charge, perhaps, for that individual. So the person could plead guilty and get a relatively modest sentence in return for the cooperation and putting the dangerous criminal behind bars.
I was trained as a police officer over 30 years ago. And I was told in no uncertain terms at the college that if you took a statement from someone and promised them that you would only charge them with a less serious crime you had arrested them for, that they gave you a statement of admission to the occurrence, that not only would your statement be tossed out of the court, but you would likely be tossed off your job. And I think it's a double standard that we set up a situation where judges can do the very same thing. You don't make deals with criminals or potential criminals.
As a practical matter, though, could this not mean that a dangerous criminal would go free because of inadequate testimony for the trial, and in order to send to prison some relatively minor accomplice, you would lose the big fish?
If he's an accomplice and you're charging him with an offense, and there's a plea bargain made by the defense and the Crown behind closed doors, no. I'm not talking about laying a lesser charge in the first place. I'm talking about plea bargains where a charge that before the court is reduced for a guilty plea on agreement between the Crown Attorney and the District Attorney, as I understand it.
Yeah.
District Attorney. What am I talking about? I'm watching too much American TV. Crown Attorney. That is underhanded. It's secretive because there's no documentation as to how it came about, no transcription, no recording of why and the wherefore, how they arrived at that, even with or without publication.
But this is pretty much standard procedure in law enforcement. I'm thinking of
that doesn't make it right.
I'm thinking of the Whitewater case in the United States. There's a report that former high official in the Justice Department is going to plead guilty to 2 felony charges. He'll presumably get a sentence that has been negotiated. And in exchange for that deal, he will testify against other people who perhaps are bigger fish, perhaps getting closer to the presidency.
The purpose of the criminal justice system is to keep us all honest. I don't consider plea bargaining honest. And if the justice system is not operating in an honest manner, how can they expect the public to do the same?
Well, this is the ideal position to take. I was wondering if in this country a murderer might not go free and murder again because of being excessively scrupulous over a plea bargain for an accomplice who might have testified against the murderer.
Would you not be concerned that an innocent person might be found guilty because of plea bargaining arrangement? Do you trust the testimony of a co-accused against another accused?
That judgment would have to be made in each individual case, depending on the circumstances, what was known about the individual.
But we will never know if it's plea bargain because it's done behind closed doors, my friend.
Well, the testimony will be subject to cross-examination of the trial of the major criminal.
Do you really believe that Karla Homolka's statement that was only read in at her trial she'll appear finally at Paul's trial?
Well, if you are making a plea bargain with an accomplice, in order to get the accomplice's testimony against the major criminal, then the accomplice will be testifying at the trial of the major criminal, and that testimony will be subject to cross-examination.
God help us if we're depending on that to convict people.
I have a comment and then a question. First of all, my comment, Gordon, you were listing some of your I guess pet peeves about the judicial system, like parole and plea bargaining things. I have one that would be the idea of the concurrent sentence. And I think it's just ridiculous to be able to serve 2 sentences at the same time. They should be stacked on top of one another. And I think that affects the Homolka trial too, doesn't it? She is serving.
Very much so, because she was sentenced to 2 concurrent terms of 12 years, which means 12 years. It doesn't even mean 12 years. It means eligibility for parole, full parole now. This is something that the not spelling out to most people, in 4 years. But it also means unescorted temporary absences after 2 years for rehabilitation purposes. It means escorted passes, because it's not a life sentence, from day one of your sentence, with the approval of the institutional head for rehabilitation purposes, such as parental responsibilities. This is escorted for a whole slew of reasons. And that's one of them.
Okay, Craig, if you'd like to go ahead.
Yes, 3 quick questions. Mr.
I say one and you say
Mr. Helwood, you very eloquently expressed the need in this debate of publication bans and freedom of speech. You said that it was perceived as a media thing. And here we have Mr. Domm doing something that basically you're saying is very laudable. My question to Mr. Domm, have you received any support morally or financially from the media? Secondly, what are your anticipated legal costs when the appeal is said and done with? And thirdly, in this heinous crime, is the person most guilty behind bars right now?
We'll answer that third question.
Yeah, the third one's a touchy one.
if you want to leave that one, we understand.
Now, what was the first one again?
Have you received any support, moral or
I have had moral
from the
support.
media outlets?
Moral support, yes. But I think it would be inappropriate for them to give me financial support when they have an appeal of their own pending before the courts. And what was the second question?
Secondly, your anticipated legal costs when all is said and done.
Yeah, okay. I have an estimate that I've just received to take it to the Appeal Court of Ontario. A low-end estimate of $22,500, a high-end estimate of $29,500. My lawyer, Frank Adario, who's an associate lawyer with the Clayton Ruby Law Firm. He's been representing me so far. I have no doubt in my mind that I will not have to pay a red cent of that, because my donations are coming in very well for the first stage. We don't want innocent people convicted. If it's going to be done because of plea bargaining, it certainly doesn't justify plea bargaining. How can you trust the evidence of a co-conspirator in a serious crime anyway? I'm going to go beyond my bounds now. How can we trust the evidence of Karla Homolka? And she didn't tell the truth when her own sister was found dead in her parents' home. And she was there all the time. If she had told the truth, she certainly would have been charged with that crime. Surely. Regardless of what deal she made. I can't help myself. I'm under control.
Okay, well, at that point, I'll cut you off. What I'm going to do
maybe that's for the best.
Should Mr. Domm's conviction hold on appeal, that the law has to change there needs to be restrictions on the ability of judges to put bans of publication simply on a whim.
We vote them in as MPs in particular ridings. And the Prime Minister, the Premier of the province in this case, votes the Attorney General in. It's a very bad decision. There's a new book. There's a new book out now, Karla's Web. Blackout portions that are covered by the ban that you will not be able to read due to an inking process in the printing of this book. But I have talked to a couple of my author friends and suggested that they do a follow-up and call it Marion's Web. I'm talking about Attorney General Marion Boyd, because she's netted quite a web here and distorted our laws that were already so sadly distorted, twice as badly as they were before she got involved in the Justice Ministry of this province.
On April 28, 1995, the governing NDP dropped the writ for a general provincial election in Ontario. Almost 3 weeks later, on May 18, 1995, the leaders of the NDP, Liberal, and PC parties participated in a televised leaders' debate. Paul Bernardo's trial had started earlier that day. In opening comments, the the Crown revealed that Karla's sister, Tammy Lynn Homolka, had been drugged and sexually assaulted not only by Bernardo, but also by Karla, her sister. Ontario went to the polls on June 8, 1995, and tossed the NDP out of office. 11 days later, on June 19th, Karla Homolka took the stand as the Crown's most important witness against Bernardo. As expected, Karla portrayed herself as the helpless victim who was simply acting out of fear of Bernardo when she abducted girls, drugged them, sexually assaulted them, and assisted in the disposal of their dead bodies. An expert on battered wife syndrome would later be brought in an effort to make sense of Karla's apparently eager participation in videotapes of the assaults of her sister, Mahaffey, and French. Then, on June 29th, the public was told all about the May 18, 1995 deal that Karla had struck with Marion Boyd's Office of the Attorney General. In exchange for her testimony against Bernardo, she would serve 12 years in jail with eligibility for parole just 5 years into her sentence. Most importantly, she would not be charged with the sexual assault, drugging, or death of her own sister, Tammy Lynn Homolka. For almost 2 years, the publication ban made it easier for Marion Boyd and others to continue the radical feminist narrative in which Karla Homolka was a helpless victim. It also ensured that nobody learned the shocking, outrageous, and unjust details of Boyd's so-called deal with the devil until after the election of 1995.